Saying previously when you weren't making contact and you left?
No, I wasn't. I wasn't actually at that location, but that's where my closing items were.
Okay.
But that's where I have keys to the place with Danny
It's
on.
4950 Washington Road.
Yes, sir. Apartment L4. Apartment L4.
Apartment what?
L4.
L as in lasso?
Yes.
Okay.
And what's the contact information for somebody there? Are you living by yourself?
It's 678-206-9878.
And who's the person?
That's Danny Armstrong.
Okay. All right, we'll check on it.
So, Mr. Jenkins, that may get you out a few days earlier if BHTC can confirm the address and confirm that it's a safe address for you. Then we just need to get that ankle monitor on you, and we'll try to get you back into BHTC. You heard Ms. Primovic. I'm going to amplify on that. We're going to give you another try. It's important that you commit yourself to the program and don't get scarce on us. Sadly, the program isn't quite what we'd like it to be right now because of all the social distancing requirements. But that doesn't mean that you shouldn't participate. So if you need to be at Hope Hall on day X, you better be there. And if you need to be connecting with your clinician or with your case manager, you got to make sure you do that, okay?
Yeah, I have a question, Your Honor.
Yes, sir.
How does the ankle monitor, how do I get the ankle monitor? I've never, how does that work? Actually,
so we'll pick you up and the investigators will meet with you. They'll put the ankle monitor on you, tell you the procedures, the protocols, give you a curfew. So we'll walk you through all that once we pick you up from the jail.
Okay, thank you, Mr. Tucker.
You're welcome.
Anything else, Mr. Jenkins?
No, sir, that's it.
All right, let's make it work this time, all right?
Yes, sir, thank you.
Take care, sir. You can do it. Come on.
Thank you for the opportunity.
Okay.
Your Honor, that last case included my business. May I be excused?
If you are done, Ms. Hall, you should enjoy your Friday.
Thank you. Y'all have a good holiday weekend.
You too. So Thornton Simmons should be next. Are you Mr. Simmons?
Yes, sir. Yes, Your Honor. Yes, I am.
All right, I'm Judge McBurney. Nice to meet you, Mr. Simmons.
Nice to meet you, Your Honor.
Mr. Simmons, Ms. Primovic is going to tell us what your situation is and why you are joining us today.
Yes,
Good morning, Your Honor. Mr. Simmons is going to go back to BHTC. They're looking for his housing. A hold has popped up and maybe it's gone away again, Ms. Cheryl, if that's happened. But made some calls. It's a Sonora Police Department has a new open case on him that he is yet to be arrested on. It's for some false ID, some bad checks, some issues like that. They would not release the hold. It is through the county that's Sonora, whatever county. Pardon me?
Is it Cherokee?
So, thank you. So he will have to be given, be released to that hold, a signature bond, kind of like what we did before and we have done in the past. Release him there, and then we would put a accountability warrant on him and pick him up from Sonoya. We're hoping that it doesn't, what's going on out there doesn't delay him too much. We've been looking for housing for him. The program is looking for housing for him, but at this point in time, unfortunately, his housing is going to be at another jail for a moment.
And you're saying Sonoya, S-E-N-O-I-A, that's?
Police Department.
Okay, that's who's looking for him.
Correct. It's
Okay.
from a September warrant, September 19th warrant, and they're new charges. So he hasn't even been, formally charged from the DA's office at all. So we don't know how long this will take. So
Okay.
hopefully not long.
We may need to do then the 1-2 of signature bond and then hold to
Yes,
get
sir.
Mr. Simmons to Sonoya. And then when he clears that up, Fulton would get a call to collect Mr. Simmons and bring him back here.
That's what we would like, Your Honor, yes.
And this
Okay.
defendant has 2 holds for Cherokee and Coweta counties.
The Cherokee is the Sonoya, the Coweta County. Ms. Sellers, did we talk about the Coweta? I don't remember seeing that. That must have popped up and new. So we'll probably go to Sonoya, the Cherokee, then the Coweta, and then we'll get him.
And the Cherokee
gonna
is a
be a little bit.
2014 case.
Pardon
The
me?
Cherokee County case is a 2014.
Oh.
We might
Well-
be able to get the Cherokee one taken care of. I was speaking with records at the jail, and they were trying to assist as well. And right now, they were not willing to take the hold off, but they're contacting probation to see if they're willing to release the hold for now. So we might be able to work through the Cherokee County one.
Well, let's do this. It sounds like, Mr. Simmons, you've been busy in some other jurisdictions. The ultimate goal here is to get you into BHTC and to get you to stay in BHTC. There's some checking that we need to do, and it may be that you take a few stops on your journey. We will get you back here and we'll get you into the program, and we need you to stay in the program. You only benefit from it if you're participating, and you detract from it if we're having to try to track you down. So we'll help with the housing. An ankle monitor helps us track you down. But before we can do any of that, it sounds like there needs to be some clarity about what's happening in Cherokee County and maybe even Coweta County. I will sign the paperwork that's presented to me that will get you on your way and then hopefully get you back here. I will say this, it may be tempting to you if you are physically released from either Coweta or Cherokee because our paper trail didn't work well, to just disappear. I don't recommend it. If Coweta lets you go because they forgot about our hold, or we put our hold in Cherokee and not in Coweta, you would do yourself a great service to reach out to Mr. Tucker and his team to say, I just got released. I'm standing on a street corner in Coweta County. What should I do? And we will help you out. We will not help you out if you decide to go on a binge because you are suddenly a free man and we don't hear from you for 6 weeks. Your lifeline is to get back plugged in with us, okay?
Thank you, Your Honor. Yes, sir.
All right. So I will take a passive role. I will wait for paperwork to be sent my way. After Mr. Tucker's team tries to sort some things out in Cherokee, we may have a Coweta thing to work out. But know, Mr. Simmons, that the end game is to get you back to Hope Hall, okay?
Absolutely.
All right, Ms. Primovic, anything else for Mr. Simmons?
No, and thank you, Your Honor.
Okay, Ms. Sellers, anything else?
No, Your Honor, nothing from the state.
Okay, thank you.
God bless. Thank you. Thank you, Mr. Tucker.
Welcome.
All right, that gets us to Mr. Clemens.
Yes, Your Honor. He has 2
Let's
items.
make
on the
sure this is
calendar.
Mr. Clemens. Are you Mr. Clemens?
How you doing, Mr. McBurney?
Hello, Mr. Clemens.
How you do, sir?
Okay,
Your Honor,
so Ms. Primovic, what are we doing?
Yes, sir. We're doing a probation revocation on number 6, the 17 SC case. And he has a new case, number 7 on the calendar. It's a 19 SC case. It's a theft by receiving. It is out of Farmer. Ms. Sellers has got a hold of the assistant district attorney over there, and we're asking for a signature bond on that case, the theft by receiving stolen property. And then one day down the road, we will plead him into a track 3 situation once all the paperwork and everything gets worked out. But we're asking for the revocation. Wait a minute, we won't be, yeah, we don't know what we're gonna do, Judge, with number 7, the theft by receiving, so we're asking for a signature bond. And then we are asking, I think it's stipulated, Your Honor, the revocation hearing. We're asking for time served, Your Honor, revoke 90 days, commuted to time served, and let him go out and start doing outpatient and stand. He has a very supportive mother, Miss Bailey, who calls and talks to me all the time, who checks on him. He would have to go and get evaluated by STAND. I called and talked with them a few weeks ago. They said that they are doing counseling. They're not doing group counseling, kind of like BHTC and our accountability courts, but they are doing counseling over the phone, some individual counseling, but he needs to call and make an appointment with STAND. And to get an evaluation and do what counseling. And to give you a background on Mr. Clemens, Your Honor, he's 53 years old. He's been struggling with cocaine for many, many, many years. He graduated high school, he's an auto mechanic, and he really wants to work hard to get his commercial driver's license. So he was doing really well. He graduated Trinity House in July through January. And then everything just started happening. No more interaction with his peers, his church, or counseling after the epidemic stopped. I talked to his mom, Miss Bailey, and she confirmed that he was doing really, really well. But the last 2 months, he was just, he just needed his peers, he needed counseling, he needed constant interaction, and he didn't have it, and he didn't really know how to handle it. I spoke to his sponsor, Randall Huff, who will continue to be in his life. And so he wants to continue with his sobriety and with his help, Your Honor. So we're asking for him to be given that.
So help me understand why it's not a plea at this point on 7. What the calendar says is plea. That doesn't bind us in any way, but if he's being terminated from drug court in 6, how would 7 be a plea into drug court?
I misspoke, Your Honor. I didn't mean to say a track 3. It was a plea. I was looking for someone else. A probation with the same conditions.
Okay, so Mr. Clemens may have been in drug court as track 3 and track 1. Position 6 was track 3, position 7 was track 1, or number 7 just could be new and it wasn't part of drug court, but it needs to be resolved. Why are we not doing that today? What in your mind needs to happen between today and whenever Mr. Clemens would next be in front of a judge if he got a signature bond?
We would just have to have Judge Farmer transfer it to us to let us do it. It would just be the paperwork.
Okay.
To do that. Ms. Sellers and I talked about this on Tuesday, I believe, and she talked to George Jenkins, the DA, and he agreed to a signature bond on this and then handle it whenever. Or, Your Honor, we could work on you handling it. I just would need to talk with him about the plea and his rights and all those things, which I have not done, and we could try to handle it all together. I'm fine with that too. Whatever Your Honor would like.
I'm not trying to usurp. Yes?
This case is already in drug court, and he was terminated on April 29th for the 19 SC case.
Yeah, that's what I was just trying to look up because that's what the calendar says. Yeah. Oh, and with Ms. Usher. Okay. I know Ms. Usher. So
Hi.
Mr. Clemens, drug
Hi,
court.
Judge.
Yes.
I could help to provide some clarity. Mr. Clemens was in drug court. Initially, he was admitted to drug court back in 2018 with the 17 SC case. He subsequently picked up a new charge. That charge was brought into drug court back in July of 2019. So both of those cases are in drug court at this time.
Yeah.
He was terminated, as Ms. Vortis said, back in April for non-compliance. The defendant was showing up. However, he was non-compliant in other behaviors that the staff stated that, hey, you can't stay in the program. And so we're ready to go forward on the revocation, but it looks like at this time, just not ready to go forward on the plea. And that hasn't been through those channels of, it's still of final plea and all of that. So there's still he still has some availability if he wants to go to trial on that case. I will say that on that particular case, the 19 SC case, the newer case, that there were co-defendants in that case. It is a theft by receiving stolen property, and I know that at least one of those co-defendants has taken a plea to that case, but he was allowed to come. That case was allowed to be brought into drug court on a track one.
So the co-defendant is Ms. Usher, who I know and you know. She was with me in drug court, and she was terminated from drug court in February, and in March, she got 90 days revoked and had to do MADRC, et cetera, et cetera. So that's the only co-defendant in the 19 SC case. Ms. Usher's done with drug court, didn't work out for her. You'll remember she had the older gentleman that she spent time with and then took his watch, et cetera. So Mr. Clemens has been in drug court for a while. This is not a Judge Farmer case. It's a drug court termination
I'm
case.
sorry, Your Honor. I thought when I talked with I could be mixing up my cases, that they were going to do an signature bond, and this was in Farmer. I totally just must have wrote my notes down improperly. I'm sorry about that.
That's okay. And I don't want us to get bogged down. I know there's someone down at Union City who's saying we got to shift to the female defendants. But I'm just looking at Mr. Clemens's docket for the 19 SC case, and he went to the case was transferred to drug court by Judge Farmer. So there's a Farmer connection, but that was in July of last year. So it's been almost a year that it's been a drug court case. So Judge Farmer doesn't have anything to do with it, and Mr. Jenkins doesn't have anything to do with it. It would be a case that the judge who was presiding over Mr. Clemens would be handling. And I think that's Ellerby. Judge Newkirk actually signed the termination order because that came up during this COVID time when we are partnering on handling all of the calendars. Yeah, Judge Ellerby has his case, or had his case, till he was terminated. So I'm not going to give him a bond on the 19 SC case. We don't need to take the plea today. We can get him on another one of these calendars post haste, but it will be one of us who works through what happens with the 19 SC case.
Okay, Your Honor. I mean, maybe we can get him on, I don't know. Well, that's too soon on Tuesdays. You have a calendar Tuesday, because I can talk to him this weekend and get him lined up for a plea or not. And at least we can keep him on track. Whenever Ms. Cheryl, that it is an opening for Mr. Clemens, because I can talk to him this weekend.
Yeah, why don't we work through that, and I'll help as well in working with Ms. Leith, who is the calendar controller for these calendars, and we could get Mr. Clemens on there. And why don't we just keep 6 and 7 together? So we'll punt today on the revocation, but we ought to, I want to be clear. I'm not applying any pressure to Mr. Clemens. If the nature of position 7 is something where Mr. Clemens isn't interested in entering a plea, and frankly, he shouldn't enter a plea because it's a terrible case, meaning the state has no evidence, then that's a different discussion. But I think that we ought to sort out 6 and 7 together, unless you conclude, Ms. Primovic, after you confer with Mr. Clemens and you look at the file, that you would never advise Mr. Clemens to plead to position 7. And if that's the situation, then we can have a discussion about bond following his revocation in position 6.
That sounds great, Your Honor. And if Ms. Sellers could just email me that discovery. And Mr. Clemens, if you can call me this weekend. Do you have my number? Let me give it to you, okay? Have them write
Mr.
that down
Clemens,
for
you're
me.
on mute. Someone's gonna need, there you go.
Can you have them write my number down for me?
I have your number at 7978, but what's
Yes.
going on here is,
612-7978.
yes,
Call
ma'am,
me.
we're only able to rotate out 1 hour per day. And tomorrow I will be able to do it after 3 o'clock.
Okay, call me after 3 tomorrow.
Yes, ma'am.
Okay, sir? Okay.
And
All right, so
he has 2 years, 10 months, 18 days remaining on probation.
2 years, 10 months. Okay. And Mr. Clemens, I'm not trying to throw cold water on things. I think it's much more efficient for you if we resolve these two matters together, but that's only with the presumption that the newer case, the theft by receiving, the case you had with Ms. Usher, is one that you want to resolve. And you and Ms. Primovic need a chance to talk about that in private. It may be one where, I'm making this up, but you're caught with the property in your hands. You ought to work that one out. It may be one where it was all Ms. Usher. And if we look at her plea transcript, she says Mr. Clemens had nothing to do with it. He didn't know about it. And you don't need to answer any of those questions because they're not questions. You and Ms. Primovic will talk about that. She can talk with Ms. Sellers and we'll figure out what's going to happen with the newer case as well. But we ought to try to sort them out together if possible.
Okay.
All right?
Yeah, it's kind of complex, you know.
Okay. Well, that's why you're going to have a good conversation with Ms. Primovic. We do have some info in that Ms. Usher already pled and that case is out there. So that'll be something for Ms. Primovic to take a look at.
Yes, sir. At the time, Judge,
Okay.
at the time, they were asking that my third party, I had a cousin in the vehicle also. They were asking that with his testimony, that they would drop the case on me, but Judge Edeby was in a rush to get the case resolved. So she just pulled it in on the drug court and I wasn't able to get the third parties, the third party that was riding with us.
We'll
We'll
talk about all that, okay, Mr. Clemens? And if not a plea, then we'll ask for a bond hearing on that, your new case. Okay,
Yep.
sir?
Thank you.
And we'll do just that. All right. Thank you.
Thank you, Judge.
I'll get that discovery to you, Ms. Primovic.
So that was 6 and 7. I think next we are doing Ms. Grant.
Okay, they can hear you.
Are you Ms. Grant?
Yes.
All right, Ms. Grant, I'm Judge McBurney. I happen to have your case, which is a coincidence today. I'm handling cases for all sorts of judges, but I'm the judge who now has your case. It was Judge Reeder. Her caseload has gone to me, and we need to work through your situation. We're going to get on the record in just a minute. So Mr. Forte, the court reporter, will be taking everything down, but I wanted to introduce myself so you could understand who the judge is, and it so happens it's the judge who's got your case. Mr. Forte, are you in a position to take things down? Great. So, Ms. Grant, you are indicted for murder, and at one point you had filed some paperwork, and then Mr. Franklin, who's your attorney of record, had shared with me as well your desire to represent yourself. And I want to make sure we get clear on the record right now that for the time being, at least, that is no longer your desire. Is that correct?
Yes, that's correct.
So you are comfortable and willing to have Mr. Franklin, who is a very senior and experienced defense attorney, continue to represent you?
Yes, that's correct.
Great. If you change your mind, you're allowed to do that. You'll need to let Mr. Franklin know, and then you and I and Mr. Franklin and the prosecutor would have to have a pretty long conversation about your rights and the wisdom and lack of wisdom of self-representation. But I want you to understand, you are free to change your mind if later on you decide that's what you need to do, okay?
Yes.
But until you tell me differently, Mr. Franklin's your lawyer, and he's the one who files motions and makes argument, et cetera. Do you understand that?
Yes.
Okay. Before we dive into bond, I think you've been re-indicted, and I also think we have Mr. Pinion on the line, and maybe he can get us procedurally up to speed as to where we are with Ms. Grant.
What you have, what you can have.
Mr. Pinion?
Yeah, yes, Your Honor.
Yeah, he's fumbling everything.
The case has been re-indicted. It added charges in the 20 SC indictment. The defendant has not been arraigned on that, so I don't know if we can do that today, but that may be something to consider.
We'll talk about what we're going to do in just a sec. Can you give me the old indictment number?
I can, just 1 second, I'll pull it up. It's 18 SC 160502.
Are you null processing the 18 SC?
I will, as long as the bond is transferred over to the new indictment.
So two things. I have learned through another judge that statutorily, the sheriff is unable to transfer bonds if there's a new indictment number. Yet another reason we are actively encouraging the clerk to keep the same indictment number for re-indictments. But for the pandemic, I think that would have happened by now. But it is in the not too distant future that we will stop getting new indictment numbers for re-indictments. So Ms. Grant has no bond on the 20 SC, and we're going to talk about bond today. We won't do the null pros until we work through whatever we're going to work through today, but I have your oral motion to null pros the 18 SC once we get closure on bond for the 20 SC, Mr. Pinion?
Yes, Your Honor.
Okay, great. I was instructed by Ms. Nelson to ask you that. All right, so there's a new indictment. It adds some new charges. Ms. Grant sits in jail with no bond. And I believe from my review of the docket, it was a complicated situation under the old indictment in that she had a bond and then Judge Reeder made a decision that undid that bond, and Mr. Franklin had worked to get Ms. Grant in front of me to have a conversation about reinstating or unrevoking or whatever the verb would be, the bond that Ms. Grant got way back when. We're in a different posture now because there is a new indictment that adds charges. There is no bond for those new charges, and I would need to set an entirely new bond for this new indictment. The sureties on the old bond are able to collect whatever they put down, but the sheriff is not able to transfer funds from a bond on an old case to a new case. So what I thought we would do today is two things. Find out from Mr. Franklin if Ms. Grant is waiving arraignment, so we could take care of that. And then number two, talk about bond. It's the same case, as I understand it. There are new charges, and we can talk about those, but it's not a new murder, as I understand it. Is that correct, Mr. Pinion?
That's correct.
Okay, so let's start with arraignment. Mr. Franklin, have you had a chance to talk with Ms. Grant about whether she's willing to waive arraignment on the new indictment?
I'm not, Your Honor.
She is not, or you have not?
I have not spoken to her about waiving arraignment on the new indictment.
Okay. Well, hopefully you can have that conversation with her, not today, because we're needing to move along, but it would be great if that's what she's willing to do, not to have to drag her back in front of a camera for an arraignment.
Yeah, I attempted to schedule a video visitation with her, but the schedule for Union City is booked out through the middle of June, so I wasn't able to.
Wow.
Okay. And I tried to make the arrangements for her to call me, but the person who I dealt with at Union City said it didn't work that way. So I've tried to make time for her and I to speak in detail over the past week and a half, and just haven't been able to reach her.
Okay. Well, I appreciate you making the effort. Ms. Primovic?
Yes, Your Honor, I just want to tell you that I was informed the same, and that the same services we have at Rice Street, we do not have down there.
Okay,
So,
it's a different facility, and I appreciate
Yes,
the work that the
Absolutely.
sheriff has put forth to create some communications, and
Absolutely. Thank you,
hopefully
Your
we'll
Honor.
be investing in more, because those folks need to be able to connect with their lawyers as well. And Being booked through the middle of June is an issue, but we'll take that up separately. So then, Mr. Franklin, are you prepared to talk about bond, or do you need time to talk with Ms. Grant before we talk about bond?
I'm prepared to talk about bond.
Okay, well, why don't you get us started?
All right. So I'm not sure if the court was able to review, or if it was a while ago that the court reviewed my actual motion. But the circumstances are as such.
Before you go further, is your motion filed under the 20 SC or the 18 SC case?
It is filed under the 18 SC case.
Okay. Keep going.
Ms. Grant was initially arrested on this case on the murder charge and associated charges on March 7th of 2018. She had been in jail over 90 days and had not been indicted, and accordingly she was given a bond, a straight bond, on June 18th of 2018. That bond was in the amount of $135,000. Ms. Grant had private counsel for a time. She relieved private counsel of representation. I assumed her case. I began representation of Ms. Grant, and due to some court administrative things, we knew we weren't getting to her case before a jury for some time. We knew that she had a hold that would have been preventing her from doing anything with the bond that she had at that point in time, the $135,000 bond. So I was able to get Judge Reeder to agree to allow her to go to Gwinnett County. She signed a signature bond so she could address the hold. And then part of that condition was to be brought right back to Fulton County. It was never anything in my estimation or thought process that doing so to effectuate some, procedural clarities would result in her losing the $135,000 bond that she had obtained because the state took too long to indict her. So we are simply just asking for the bond that was given to her because the state took too long to indict be put back in place. I've made this argument before Judge Reeder before, shortly before we were actually brought before Your Honor, transferred to your courtroom. She denied our motion, but just given the circumstances, no disrespect to Judge Reeder, I just believe she was incorrect in her ruling because Ms. Grant did not participate in anything that would otherwise have revoked her bond. She went to address the probation hold related to a first offender case. The complaining witness in that case is her mother. Her mother would like for her to get out. Ms. Grant, it was a few weeks or maybe about a month before her arrest, had just given birth to her daughter. She has not been able to hold her daughter for a period of over 2 years. We believe that if the court has any additional concerns, certainly an ankle monitor or house arrest will be appropriate conditions if she's able to make a bond. But it's been 2 years and we have a new indictment. We believe that she should be able to have the opportunity to meet her initial $135,000 bond that was granted in June of 2018.
Mr. Franklin, the case out of Gwinnett, the hold was for probation matter. She had a first offender case out of Gwinnett.
Correct. It was a first offender aggravated assault related to an argument that she and her mother had. She had gone out with a guy, and she was younger at that time, of course. Came home, was intoxicated, and her mom wanted her to get in the shower or something like that, and a fight ensued.
Okay. And what was the result of going to Gwinnett?
They did not revoke her. They continued her on probation for the time being, presumably to wait until the outcome of this case.
Okay, so it's not the situation that Ms. Grant would be going to Department of Corrections or something if she got a bond here because Gwinnett revoked 5 years or something like that.
Correct, that is not the situation.
Okay, all right. Mr. Pinion, tell me what's new about the 20 SC indictment, and then give me your view about what should happen with bond. So your argument, but also address legally if there was something that happened that was legally erroneous in eliminating a bond that had been set upon Ms. Grant's return from Gwinnett.
Well, I'll address the last part first. I would say that issue is not the, Your Honor could reset that $135,000 bond on those particular charges if you felt that the judge did not have the right to revoke that. Although I think she could have found new circumstances to revoke it. But I just happened to pull that bond up, and it doesn't address all of the murder charges. It only addresses, and it's in Odyssey, 3 charges: the malice murder, aggravated assault, and possession of a firearm during the commission of a felony. And it was 100,000 on malice murder, 25,000 on aggravated assault, and 10 on the firearm. Since that time, we did discover that she was on first offender for aggravated assault and theft by shoplifting. And so no bond has ever been set on the felony murder based on aggravated assault or the felony murder based on possession of a firearm by first offender.
Okay, so I see your point that we are now 2 layers beyond. I'm looking at the bond, June 18th, Ms. Grant, $135,000 good bond for 3 counts: murder, aggravated assault, and possession of a firearm during commission of a felony. That bond does not cover the 18 SC case, nor does it cover, or could it have covered, the 20 SC case, because there are additional charges. Now I'm going to hear argument about why that's the dollar amount that should remain, because it's effectively the same case. And Judge LaGrua in June of 2018 signed the bond saying $135,000 covers these facts and circumstances. And what has changed is not that Ms. Grant was the first offender probationer. She was presumably back in June of 2018. And what hasn't changed is the facts and circumstances of the allegations. What's changed is the state has first indicted it in 18 SC a certain way, and then ultimately revised those charges. So I guess we ought to talk about what's changed with the 20 SC indictment. I want to understand that. And then what the state's view is as to the propriety of a $135,000 bond for this case. That's how I'm seeing it. But I don't think, now that you brought that to my attention, Mr. Pinion, that Judge Reeder did something right or wrong. I think we've been miscasting the argument. Ms. Grant has never had a bond for the charges as brought by a grand jury. It doesn't exist. She has a bond for unindicted charges that don't match one for one with either of the indictments, both of which are in effect right now because we're not doing the null pros quite yet. But more specifically, they don't align with the charges in the 20 SC indictment. And so we need to talk about, is bond appropriate? And if so, what's the size of that bond? And Mr. Franklin's already started the discussion, ankle monitor, house arrest, et cetera. And I'll circle back to him, but why don't you tell me, Mr. Pinion, what has changed in this new indictment, and then anything else you want to add about the propriety of bond.
All right. And Your Honor, before I forget, I just want to mention that the Tevin Herring's family, Barbara McGee, and also his brother are watching this, or one on YouTube and the other is with our victim assistance.
I need to work on my stuff.
And
I want to finish that report.
Hey, Ms. Vortis, you're not muted. Thank you.
All right. And Your Honor, the what happened since arrest, as I just said, was we did find out that she was should not have had access to a firearm. We pulled the aggravated assault case. We've actually filed it as a 404B motion. And just without going into all the details of the case, it took a long time to make an arrest because the defendant gave false statements and said she was not there at the time that the victim, Mr. Herring, was shot 4 times and killed. It wasn't until our office actually started working with the police to check through Google satellite location where her cell phone was. And I actually was one of the ones working on that. And we found that her cell phone was at the scene within 10 yards of where the shots were fired that killed Mr. Herring. And so for well over a year, she had denied even meeting Mr. Herring or being or knowing anything about it. And then once we got the Google records back, and I was very familiar with it, I wanted to add that the false statements. I felt that gave the full picture of what had happened and why an arrest was delayed, and the tampering with evidence, because this was a ridiculous case, like most of them. The murders, it was over a cell phone, and the victim's cell phone was taken. Mr. Herring's cell phone was taken from him at the time that he was shot 4 times. And so once the defendant made a statement admitting she was present, that some item was taken from the victim, Mr. Herring, I added the tampering with evidence charge and the false statements.
So 8 and 9 are counts 8 and 9 of the 20 SC indictment are new.
Yes.
Okay. All right.
Yes.
So given that the only bond in place, if it's still in place, was for only some of those charges, what is the state's position on bond for Ms. Grant? Why would she be a risk of flight or a risk of intimidating witnesses, et cetera?
Well, Your Honor, first, in this case, we know that she has no problem lying to law enforcement, so I don't believe she is a great candidate to follow court's instructions. She had, as I stated, for a long time, flat out on video, told the police she was not there, did not know how Mr. Herring died, and then she changed it to her boyfriend is the actual gunman, and then he has now died in a separate armed robbery. A person she was saying was with her during the cell phone exchange, a boyfriend of hers, has committed another robbery and had subsequently died during that armed robbery in DeKalb County. So we know she associates with criminals by her own admission. And I have actually that boyfriend's record. He had a long Fulton County record as well. But she fled the scene in this case. In the aggravated assault case on her mother, which she was living with her mother, so I don't know where she would go if she made bond now, but she beat her mother over the head with an iron, and the police arrive and there's blood all over the place. And then they go hunting for Miss Grant. She had fled at that time. So in 2 cases, we believe that she shows a pattern of flight. And the police didn't find her until they found her at a Walmart nearby, and she has shoplifted some knives, which she has pled guilty to, and was found in the bathroom threatening to commit suicide with the knife to her. So she has erratic behavior. She has a history of violence. Your Honor, while we were waiting on this hearing, I pulled up in the jail and she was just adjudicated for more violence at the jail with fighting with another inmate. And that was this month. You can see that on Odyssey. And when officers tried to break it up, then she spit on the person that she was fighting with. So she wasn't following instructions at jail. She's had her privileges taken away. I believe it's through halfway through June. Given the serious nature of the aggravated assault in Gwinnett County, we believe that she's a risk of flight, that she's a risk to not follow the court's instructions and reappear, and that at the time of this homicide, she was staying at a weekly hotel with criminals. The two people she states that she was with were long-term criminals, one who's now died while he was actually an armed robber, and the other person has been in and out of jail. The other case, she was living with her mother and attacked her, so she doesn't really have a stable background of a place to reside, a stable address to show that she would appear in court. I know of no stable work history. So I believe that given the recent fight in the jail and that she is a risk under the Ayala factors not to appear, and a risk to not follow the court's instructions, and a risk of further felonies.
Mr. Franklin, you can talk about, if you want, the situation with the procedural situation with the bond, but it does sound like, now that I've been able to look at the docket, the bond that Judge LaGrua set in June of 2018 was for the complaint. She couldn't set it for anything else. And then, not unsurprisingly, when the case was indicted, there were additional charges added. And so I don't think it's factually or legally accurate to say the 135 magically spreads across all of the charges in the indictment. I think what you do have is a fact and a persuasive fact that a judge, understanding the situation, perhaps driven more by it's been more than 90 days, but nonetheless, I'm confident Judge LaGrua got an earful from a prosecutor about what this case was about. And she set a bond for this same framework of charges, maybe minus the false statements and the tampering with evidence. But Mr. Herring was shot 4 times. That was known to the state back when they would have argued against the bond being set in June of 2018. But I don't think the right approach for me would be to reinstate. It would be to look at the 135 as maybe a lodestar, that a judge has already heard this and thought that that was an appropriate amount to address concerns about Ms. Grant's flight risk, et cetera.
Understood, Judge. To some extent, I think at least part of the state and the court's position, as it pertains to the original murder charge, the aggravated assault, and the possession of a firearm during commission of a felony, being that those were in place, perhaps those are the charges that definitely apply to my initial argument. I think it's kind of absurd, honestly, that Mr. Pinion is making an argument that since they added 2 additional felony murder charges, which basically just charge the same murder charge in a different way, that because they use different words to charge things for the same body, that there should be some other amount that's added on to that. Additionally, I mean, Judge LaGrua wasn't in a place to set a bond on certain amounts because the state took a very long time charging Ms. Grant under an indictment. They chose not to take it to grand jury for 90 days, which is even more absurd under the fact that Mr. Pinion tells us they had a year-long investigation and that Ms. Grant had dealings with them for a long time. That brings me to the question of this assertion that she has a propensity to flee, or she's likely to flee. if the police had been talking to someone for a period of time longer than just the day that she said, yeah, I was there, the time to run would have been before then. Any likelihood that she's going to run from her charges would have occurred before she was actually charged with the stuff. The moment that someone says, hey, I think you committed a murder, and if subjectively she knows she was there, movement would have occurred at that point in time. Mr. Pinion made a mention of the fact that he wasn't aware of the fact if she had any work history or not. We could have solved that very quickly if he just asked me. She worked at Chick-fil-A for over a year. And she was just past being a teenager at the point in time that this occurred. So it's not as if she would have some very long attenuated work history. She had work that was suitable for a person of her age. And even at the point in time that we began trying to get a bond reduction, I believe she was able to go back to work at Chick-fil-A at that point in time. It was a few months back, and I think Ms. Grant would probably remember that more so than I would, but I do recall making that argument that her job was still available to her at that point in time. So what we then have are the allegations of violence that I guess somehow support the state's contention that she is going to be violent if she were to be released now. One, this incident occurred with her mother. She and her mother are on fine terms now. That doesn't mean that, that because she did something that wasn't appropriate once upon a time, that she totally disregarded. But speaking with her mother this morning, I confirmed that, this was a situation where she had been intoxicated during the altercation. So it wasn't as if this was her natural or true character. Mr. Pinion makes mention of the fact that the cell phone that was pinging off of the location that kind of connected her to the scene. Part of the discovery mentions that the young man, before he went outside and was shot by whoever shot him, said to somebody that, let me get a gun. I need to go out here. So this wasn't a man that was going out and getting ready to go to the store or anything. He was going somewhere to prepare for a confrontation. So that's a fact that needs to be considered. Additionally, as it pertains to the incidents in jail, my communication with my client has been limited for the reasons I stated before, but I was able to get a phone call from her brother a few weeks ago, and before the phone cut off, I was able to speak to her that way. And what I know is that Ms. Grant has made several complaints and reports to jail personnel about someone who is making a shank at Union City, who has threatened Ms. Grant before. She's asked to be moved. She's asked to have something done to this person. I'm not sure if this fight that they're talking about is with that same person, but I know that Ms. Grant has done her best and is very frustrated with the fact that whenever there's kind of the who's going to be believed, I say this person was making a shank. I said that they've been messing with me. And I tell authority figures that this is the problem. Well, they look at her murder charge and disregard what she has to say. So she's in a position where she can't rightfully defend herself for someone who potentially has a weapon that could harm her while she's in custody. She's not in a position where people are actually taking the threats that are being made to her seriously. So I would argue that the danger that Mr. Pinion alleges may be present by any release of Ms. Grant is actually present for her right now. And I mean, the court is aware of this, but I want to make it very clear. She's presumed innocent right now. And she's entitled to be safe just as anybody else in that jail, regardless of what the accusations against her are. So I don't believe that the state adding additional charges that don't add additional facts to what Judge LaGrua considered should get granted any legitimate weight. The fact that the state took a year to learn that she was a first offender at that point in time, that's on them. That she could have been held on that at that point in time that she was initially arrested. That's not something that took a long time to discover. You can run a GCIC and find that out right away. So, and I will also say that at the point in time that I began representing her, her booking screen at the jail, even after indictment, only reflected the charges that Judge LaGrua had set a bond on. There weren't $135,000 on the 3 charges that LaGrua set a bond on, and then no bond on these other charges that were added after indictment, had she had $135,000 or the money to go through a surety at that point in time, she would have been released had she been able to secure that money at that point in time, because there was no other hold for this case showing from Ms. Grant. And again, this is all because, not necessarily Mr. Pinion, he just got to the case, but certainly his office's inability to do their job in a reasonable amount of time.
I have a question. Mr. Pinion made reference to several men in Ms. Grant's life. Is it your understanding, Mr. Pinion, that Mr. Herring and Ms. Grant knew each other?
Yes, they were in a dating relationship, and there was a cell phone that Mr. Herring had that Ms. Grant wanted back, and there was argument or discussion about that. And they were supposed to meet that day. Yes. And then
so at one point in time, boyfriend-girlfriend relationship, is it your understanding, is there evidence that someone besides Ms. Grant showed up at Mr. Herring's apartment the day or the night that he was shot? And I realized that really what you said is Ms. Grant's cell phone showed up at Mr. Herring's apartment. But I'm wondering what your theory is. This just helps me understand if Ms. Grant is viewed by the state as the person who shot Mr. Herring 4 times, or as a person who was involved in a scheme that resulted in Mr. Herring being shot and killed and his cell phone taken.
Well, Your Honor, the only evidence that we actually have is that she was there when we found out, because she had denied she was there since this happened. And then once we got the cell phone information and the police confronted her with that, she made the admission that she did drive. She said she brought her boyfriend with her.
So that's where I'm confused. So boyfriend is not Mr. Herring in that statement, as far as you understand.
New boyfriend.
Okay.
Brought new boyfriend to meet old boyfriend, and new boyfriend is the one that she drove him there. There was an argument, and new boyfriend shot him. New boyfriend is a long time.
Conveniently dead.
Yes, and he has, I'm looking at his record, 12 convictions, and then died when he was committing a armed robbery in DeKalb County.
Okay.
So she is the one that said that this guy is the one that pulled the trigger. She admitted then that she drove him away from the scene. So under her theory, the state's contention is she would be a party to the crime of murder.
Okay.
But
do you have any information, Mr. Pinion or Ms. Rolak, either one of you, that Ms. Grant or anyone on behalf of Ms. Grant, other than her lawyer, has tried to contact friends or family of Mr. Herring since March of 2018?
no, I mean, she was
Did you hear that?
telling them she didn't know anything. You know, she didn't know who killed him and all that. So it was the state's contention. It was a cover up, you know.
Okay. Ms. Rolak, anything? I know you are communicating with the family, and I'm not asking them to respond directly. I'm just trying to understand if they have concerns that they have been inappropriately contacted by non-legal representatives of Ms. Grant since she's been arrested for Mr. Herring's murder.
I'm not aware of that, Judge.
Okay. All right. And Ms. Rolak, did anyone from Mr. Herring's family want to convey anything to me, either through you or directly, about bond for Ms. Grant?
The aunt, Miss Barbara McKee, is currently at Emory. She's hospitalized. She's listening in. She doesn't want to say anything at this time.
Okay. And I thought there was one other family member. Oh, someone is watching on YouTube.
Yes, the brother is following on YouTube.
Okay. All right. Well, I appreciate their continued participation in this difficult process for them. All right, Mr. Pinion, anything you want to add?
Just that I don't believe that the state would have addressed with Judge LaGrua that she was a first offender. Otherwise, we would have asked for a bond to have been set on that as well. Potentially, I guess that was pre-arrest, but charges could have been not pre-arrest, pre-indictment.
So I just want to make sure I've got my dates in a line. June 18th of 2018, Judge LaGrua signed the bond, $135,000 for the 3 charges in the complaint. At that point, was Ms. Grant already under sentence in Gwinnett?
Yes.
Okay, so it was a knowable fact that may have been brought to Judge LaGrua's attention, may not have, but certainly could have been by a prosecutor who wanted to make a full-throated argument as to why bond would not be appropriate. Because of course, after 90 days, you aren't entitled to a bond, you're entitled to a hearing. A judge could still say no bond. The fact that the state hasn't indicted after 90 days, a guy who there's credible evidence killed 25 people isn't gonna get a bond. Judge LaGrua set a bond. Judge LaGrua wasn't legally required to put a number on paper. Judge LaGrua could have entered an order denying bond for whatever reasons, threat to commit another crime, risk of flight, etc., even though the state hadn't indicted yet. I mean, unless I'm wrong about the law there, whatever it was Judge LaGrua heard from both sides, may have been Mr. Gaffney at the time for Ms. Grant, and it was whomever from the DA's office, she felt it appropriate to set a bond, to Mr. Franklin's point, on the meat and potatoes of this case, which is the murder. And I know additional charges were added. I'll tell you my philosophy, in case either of you have this occur again. If new substantive charges are not being added, and this typically comes up with a re-indictment, the fact that there are now charges without a bond is not going to leave that defendant with no bond. I will spread the bond out. If it was an armed robbery and you re-indict and you add a new armed robbery, different victim, different day, that's going to be problematic for the defendant. But what if what is being added is a nuance, and an important nuance? Lying is important, and the jury, I don't think, would factor that in real favorably for Ms. Grant if the case got there. And the tampering with evidence, important charges, no reason the state shouldn't pursue them. But to me, that doesn't move a murder to a multiple murder or a murder with a rape or something like that. So I think structurally, Mr. Pinion is correct. There is no bond right now. But I think I'll call it philosophically, Mr. Franklin is correct that a judge more seasoned than I, who might be viewed as at times more firmer than I, concluded that $135,000 cash bond, given the general facts and circumstances of Ms. Grant's case. And I get it, Mr. Pinion, you know more now, and it hasn't gotten better for Ms. Grant as time has gone on, but the types of things that haven't gotten better, again, aren't, we found another victim, or he was tortured before he was shot. That's not minimizing what happened. There are not more serious charges that could be brought against Ms. Grant, but a thoughtful judge has already considered this and felt that a bond was appropriate. It's not going to be 135,000. It's going to be more, but I do find that I can craft a bond that would secure Ms. Grant's appearance, as well as ensure that she not influence witnesses. According to her, the key witness is dead. And I've got no information that she or anyone on her behalf has tried to contact Mr. Herring's family in any inappropriate way. So what I'm prepared to do, if I can get the indictment in front of me again, is set the bond. Let's get back.
Mr. Franklin, your client wants to talk to you. I know. Chief, I don't know if you can speak for a minute.
As long as let's hear what the judge has to say, and then we'll move to the second room. Is that fine?
Yeah,
okay.
yeah. Let
She
me
said
set
okay.
the bond, and then you two can certainly talk briefly, because I think the remaining inmates are in line right behind Ms. Grant right there. We don't have anyone else at Rice Street. It's all Union City folks. So
Okay.
I'm not trying to be slow. I'm just trying to get the indictment up.
Understood.
Okay, there it is. Okay, I'm going to set a cash bond at $150,000. It's $100,000 for count 1, $10,000 each for counts 2 through 5, and $2,500 each for counts 6 through 9. And that should add up to $150,000. Ms. Grant, if she is able to post that bond, will be required to wear an ankle monitor, and she will be on a house arrest, meaning she is at whatever her residence is going to be, unless she's got to go to the doctor or she needs to go to court. If she is able to secure employment, if that can be documented, then we will turn it into a curfew so that she is able to be out of the house for purposes of getting to work, working, and then coming home. Mr. Franklin, you're going to need to figure out if there is a condition on her Gwinnett sentence that prevents her from being around her mom, because I don't know where home is going to be, but we'll need an address that will be the address of record that I write into the bond, that she's required to live at location X. But I don't want you to offer up mom's address if that would cause Ms. Grant to be violating a condition of her sentence out of Gwinnett.
She'll be residing with her father. I'll confirm the address in just a moment.
Okay, well, you can get Ms. Vortis or me that address for her father. But that means if she's going to see her child needs to be brought to her. She can't go to her child. She is at her father's house 24/7, except for the few things I mentioned, going to the doctor and coming to court, and there won't be court appearances right away. Of course, all of that presumes she's able to post that bond. Her father lives in what city? Or at least, is it Metro Atlanta?
It's Metro Atlanta area.
Okay.
I think it's the city of Atlanta. I just need to confirm that.
That's okay. It's Metro Atlanta. I just want to make sure it wasn't in Dallas, Texas.
Oh, no.
Also, it will be a condition of bond that Ms. Grant is to have no contact, direct or indirect, with any of Mr. Herring's family members. Obviously, her lawyer and her lawyer's investigative team might choose to do that, but Ms. Grant may not, nor could any of her friends, family, or associates seek to contact any of Mr. Herring's family members. If any evidence of that is brought to my attention, Ms. Grant will be returned to custody until her case is resolved. Mr. Pinion, any other conditions you'd want to see on the bond besides ankle monitor, house arrest, and then the only reasons you leave are for medical reasons or court, and then eventually if work is certified or documented for work?
No, just when we know if she makes bond, what the address would be, if that.
We will. It'll be written on the bond. I will be getting that from Mr. Franklin, but you'll see it on the bond. I will have Ms. Vortis. It will literally be typed on there that Ms. Grant, is required to live at 123 Main Street, and it will be live with your father, his name, at, and then address. That will be typed in the bond that I sign. I won't sign it if that's not there.
All right. Thank you then.
Okay. All right. Well, I want to thank again Ms. Rolak, Mr. Herring's aunt, and Mr. Herring's brother for tracking this. This case has been around for a long time. That's not fair to the family. It's not fair to Ms. Grant, as Mr. Franklin's pointed out, but it's particularly not fair for a family that continues to grieve for the loss. What is not in dispute is that Mr. Herring was shot and killed, and that is a tragedy that's not fixed by however this case plays out. But I appreciate the family's patience as we work through this process. And my goal will be to get Ms. Grant closure on this case as soon as we are able to do that under the current health concerns. It's promising that Mr. Franklin has been allowed to stay on as her lawyer, because I know he's been working on her case and getting it ready for the trial that it deserves, if that's where the case is heading. And I know Mr. Pinion has as well. Mr. Franklin, we do need to deal with the arraignment. I don't want that to slow things down. If you and Ms. Grant do move into that private room, I'd ask you to have that as part of your conversation.
Yes, sir.
Okay.
Someone from Union City gave me a number to call, so I'm about to call that right now. I'm going to drop my face, and then I'll pop back up when appropriate.
Okay, appreciate it.
Thank you, Your Honor.
Okay. So
Thank you.
let's turn, I think we're now just going numerically. So next would be number 10, Ms. Hunt. Are you Ms. Hunt? Okay, you'll need to move, there we go. And Mr. Forte, I think you are good to go. I will let you know if we need anything more from you, okay? Thank you.
Judge, we have some revocations and a plea, so we will need him.
Great, he's not leaving, he's just relaxing.
Okay, taking a break, hopefully.
Yep, all right, so Ms. Primovic, tell us why Ms. Hunt is with us.
Your Honor, good morning. Ms. Hunt is being terminated today, so we'll have to have a termination, and we are ready to go forward on a probation revocation hearing after the termination.
Today?
So however you want it. Yes, Your Honor.
Okay. Well, then I'll ask Ms. Sellers to share with me. Ms. Hunt is with BHTC. So she's been working with Judge Reeder, not with me. So I am not familiar with the basis for the termination. So Ms. Sellers, or it may be, we've got Ms. Zoe here. She could tell us, but I need to hear from someone why termination is being sought. And then I can make a decision on that. And if I agree, then we can shift to what's next for Ms. Hunt.
Thank you, Your Honor. Ms. Hunt was brought into the Behavioral Health Treatment Court Program back in October of 2019 when she was sentenced to Behavioral Health Treatment Court in July of last year, where she received a sentence of 15 years to serve 1 year, and that 1 year was commuted to time served. And a special condition of that probation was for her to complete the Behavioral Health Treatment Court Program. I will turn this part over as it relates to termination to the very capable Behavioral Health Treatment Court staff. I see that Ms. Odegbami is available, as well as Ms. Lee, and I know Mr. Tucker is on the line as well. So if you all could expound on the reasons for termination.
Good morning.
Good morning.
Good afternoon, actually.
Yeah, 6 minutes afternoon. Good afternoon. You guys have been very patient.
Yes. So Ms. Hunt was brought into the program last year. She ran the first time. We put out the warrants. We gave her another chance. She came back. She was placed at our housing. And the same day she was placed at Salvation Army, she went AWOL the second time. We brought her back again and placed an ankle monitor on her. And also put her in a different housing. And then she got into an altercation at the housing and violated, tested positive numerous times. So at this point, we've actually worked with her 3 times. And at this point, we do not think Ms. Hunt is ready for treatment and would like to go forward with termination.
Okay. Thank you for that. Ms. Primovic, that to me seems like a sufficient basis to move forward with the termination. I think BHTC has worked hard with Ms. Hunt, Sounds like Ms. Hunt is working through a lot of serious issues, and maybe the
Yes.
level of care and the structure of care that we're able to offer doesn't fit Ms. Hunt's needs. Do you disagree with that?
Well, Your Honor, I don't know how intense her level of care. Yes, it does not fit. I think first and foremost, Ms. Hunt doesn't really want the services. I think obviously the great services that she had available to her because of a number of issues that she does have going on with her life that I can get to when our revocation. But yes, it does seem, unfortunately, that termination is, they've worked with her and it just doesn't seem to be a fit for many reasons, but we really can't argue termination, and she is fine with.
Okay. Ms. Hunt, is there anything you want to add about the termination piece?
No, sir.
Okay. Then Ms. Hunt, I am going to terminate you from BHTC, and it sounds like that was a condition of your probation to enter in and successfully complete behavioral health treatment court. By you being terminated, you violated your probation. Normally what would happen, and these are not normal times, is that we'd get you back here in a couple weeks so that both the prosecutor and your lawyer could spend some time thinking about what ought to happen as a result of your violation of probation. But it sounds like folks have already done that. They put that work in up front, and we're going to turn immediately to talk about what should happen with your revocation. Is that correct, Ms. Primovic?
It is correct, Your Honor. Thank you.
Okay. So why don't you tell me, well, let me learn first from Officer Calhoun. It sounds like there's a pretty big number left in terms of time remaining.
Yes, Your Honor, that is correct. She has a remaining balance of 13 years, 5 months, and 1 day remaining under supervision.
Was the first number you said 13 or 14?
13, Your Honor.
Got it. Thank you. So Ms. Primovic, what is the request of Ms. Hunt in terms of handling the revocation?
Your Honor, I'd like to give you a little background on Ms. Hunt, since she really hasn't been around for you to know, and she was Judge Reeder's. She is originally from North Carolina. She came here 2 years ago, and nothing seems to be going right for her here. She graduated high school over in North Carolina. She has 2 boys back home, ages 25 through 19. She started an addiction with alcohol and cocaine back when she was 21 years old. She suffers from post-traumatic stress, and she's on those medications. She has been homeless basically for the whole 2 years that she's been here in Atlanta. So Ms. Hunt wants to go back home. Rosie Hunt is her mother, who lives over in North Carolina, said that she could come back home if she follows keeping on her medications and going to counseling. If Ms. Hunt is willing to do all those things, her mom would like her to be home. But if she's not going to do those things, she's not going to be able to live with her mom. Ms. Hunt doesn't really want any more programs. She wants to go back home. She could handle these things on her own. So that's what we're asking, Your Honor. I talked to Mr. Calhoun earlier. Well, we were on a different Zoom court hearing together. That we discussed Ms. Hunt and the issues that we were requesting. He said that if we wanted to transfer the probation, it would be next to impossible now with the coronavirus. Even though she lives there, she'd have to stay here somewhere for months. The paperwork would have to go through. She'd have to have money to transfer, that it would take a very long time. And we do not have a place for Ms. Hunt, unfortunately, to stay, in a safe place for Ms. Hunt to stay. So we're asking for her to be commuted to her time that she has served, for her to her balance to be suspended. A condition of her suspension is that she stays out of the state of Georgia, but for the one county that you would pick, if indeed you would go with this, and with the requirement that she stays on her meds and has to go to NAAA counseling and any other post-traumatic stress counseling that she deems necessary over there.
Okay. Ms. Hunt, what brought you to Georgia a few years ago?
I was with some friends.
Who were coming down here?
Yes, sir.
Okay. And if you were granted the relief that your lawyer is asking for, you'd go back and stay with your mom?
Yes, sir.
Okay.
I miss my family. I need my mama.
Okay. All right. Thank you, Ms. Primovic. Ms. Sellers, what's the state's view on this?
Thank you, Your Honor. The state's view is a little bit different. The Ms. Hunt has a significant criminal history. She has 10 felony convictions. I don't know if you want me to read all of those out, Your Honor.
No, but if you'd let me know, are they, in general, are they, I mean, her charge here is robbery by force. So normally I'd say, is it the shoplifting or the simple possession? Are they mostly property crimes or drug crimes?
There are, I don't have any drug crimes. They're mostly larceny, breaking and entering. They're all out of North Carolina.
Okay.
And they range from 2005 to 2015.
That was my next question. So the most recent is from 2015.
Yes, Your Honor.
Okay.
And the state believes that that Ms. Hunt will actually reoffend. She's proven that she will reoffend from all of these larceny cases that she has, from receiving a stolen vehicle to larceny of a vehicle to breaking and entering charge. And then the case that she is on probation for, which is snatching someone's purse by force on Edgewood Avenue. It proves that she has a problem, and that there needs to be more than just going back home. The state's recommendation. But first, I know that Your Honor, earlier today, you provided the defendants with a bit of a litany with the Zoom hearings. And I wanted to make sure that we had all of that information on the record. Is it okay for me to ask the Ms. Hunt a few questions as it relates to the Zoom hearing that we're having today, probation revocation?
Sure, I'll do that. I had
Okay,
forgotten because I wasn't putting together the fact that we're doing something substantive as well in terms of the revocation. So Ms. Hunt, under normal circumstances, you would be here in court with me and all these people that you see on the screen. And in fact, you have a right to have this hearing held in open court, but that's hard to do these days. Are you waiving that right and allowing us to proceed virtually the way we are right now?
Yeah, we can proceed today so I can get it behind me.
Okay. The other right, you have a bunch of rights, but the other one I need to talk to you about is that you have the right to have your lawyer, Ms. Primovic, by your side for a hearing like this so that you could confer with her, ask her questions if you needed to. She's not there by your side. She is visible on the screen, but she is elsewhere. Do you waive her physical presence while we have this conversation?
Yeah, I want her to be here.
Well, she is on the screen, but you know she's not sitting in the room with you.
Yes,
Are you
sir.
okay with the fact that she's not right there in the room?
Yes, sir.
Okay, if you need to ask her something in private, we can make that happen, okay?
Yes, sir.
All right. Thank you for reminding me of that, Ms. Sellers.
You're welcome, Your Honor. State's recommendation today is to revoke 2 years and commute that to time served upon her entry and completion of integrated substance abuse treatment through the Department of Corrections.
Okay.
Or probation, through probation.
Got it. And then return her to probation?
Yes, Your Honor.
Okay. Ms. Primovic, I appreciate, I've heard it from your client directly. I've heard it from you that Ms. Hunt wants to get back to North Carolina. The state is looking to get Ms. Hunt the kind of treatment that it sounds like she needs, maybe doesn't want, as evidenced by the way she walked away 3 times from BHTC, but would be a program that would get her some perhaps long overdue treatment. What's the objection to that beyond the obvious that it's a custodial program? It's not a, I'll show up when I feel like it.
Yeah, true, Your Honor. And I understand the state's recommendation and these questions. The problem that we have with Ms. Hunt is, you know, I don't know how she will participate and how she will, I mean, it would be great if she thought she needed treatment and if she thought she wanted help, and we would be working on finding her a non-custodial program. But at this time, that is not where she is. That's not where her head is. She really, really, really misses home. She wants to go back to see her mom and her kids. I just don't know if she would be able to wrap her head around it. There's a long wait to get into those programs now. It's a 9-month program, I think, once it's in. And I just, you know, Ms. Hunt doesn't think that she would need all of that intensive work. But of course, whatever you say, Your Honor, I'm sure Ms. Hunt will do and will do well. But we're just asking for her to go back home and have the support. She's 43 years old now. Hopefully she's maturing. She's seeing, you know, her ways, and that, you know, she will stay on her medication and do what she needs to do.
Okay. All right. I'm trying to find some magic language that Officer Calhoun shared with me once.
Your Honor,
Okay.
I believe it's as determined by.
Yes, I found it. It's the email you sent me about Olajuwon.
Okay.
And I've got it right there. Okay, thank you. That's an email I saved.
Thank you.
All right. Well, Ms. Hunt, I appreciate very much your desire to get back to North Carolina. I'm also a little worried about the fact that the North Carolina you left behind is one where you got in trouble for serious enough stuff that you got arrested and it was a felony, not once or twice, but 10 times in the span of only 10 years. You've had a tough time of it. And it may be that friends and family help you through it to a certain extent, but I don't see that friends and family alone is sufficient to keep you safe and healthy. The hope was, that by participating in BHTC, you might begin to get some of the tools you need to help you navigate the challenges that life brings to you, because it's complicated out there. But I don't think it would be fair to the community you'd be returning to say, well, just stay out of Georgia and whatever happens in North Carolina happens in North Carolina. Because sometimes people ask for that and judges do that. And it's a way, I guess, to export an issue, but it doesn't really address the issue. So I'm gonna give it one more try to see if we can help you address the issue. It may not. And while Ms. Primovic is correct that the program that I'm gonna refer to in a minute has a particular duration, it has a real short duration if it's not working out. And if it's not working out, then we're gonna talk again. But in light of your termination and the reasons for your termination from drug court, I do find that you violated the conditions of your probation in your robbery case. You have a whole lot of probation left, and that could get problematic for you because a judge could say, well, you know what? You have 13 years left. I know one way to keep you out of trouble. We'll just send you down the road for 13 years. I don't think that helps you. I don't think it fixes things. But I do think that we ought to try one more time in a slightly less voluntary setting for you to get some help working through the kinds of issues that you've been working through, not for just a day or a month, but for many years. So what I am going to do is revoke your probation for 2 years, but those 2 years will be reduced to the time that it takes you to be entered into either RSAT, which is the Residential Substance Abuse Treatment Program, or IRSAT, the Integrated Residential Substance Abuse Treatment Program, as determined by the Department of Community Supervision. So I'm not telling you which one it's got to be. Smart folks who know more about these things than I do will make the determination which of those two programs you go to. You'll go to that program, and being successful there gets you out sooner. So there's a motivation to get through the program well. And upon your completion, there is some aftercare, but you would be eligible at that time to apply for a transfer of your case to North Carolina. And I am confident that by the time you completed that program, there would not be that wait list to have supervision transferred from state to state, because we would have pushed past the worst of what we're working through with this current health crisis. Officer Calhoun, have I put into words things in a manner that you'll be able to put on paper for a revocation order?
You have, Your Honor.
Okay. Ms. Hunt, do you have any questions about what it was I just said?
Yeah, am I going to Department of Corrections?
No, ma'am. You're going to go to the Department of Community Supervision, which is probation and programs that they run that are designed to get you the type of treatment that the judge who had your case tried to get you towards when you were invited to participate in BHTC. Okay?
When will I go to this program?
As soon as a bed is available, and that's a fair question. I don't have that answer. It won't be tomorrow, but there is, what has to happen first is a determination as to which of the two programs you ought to go to. And then folks will be in a position to say, well, for the program you're going to, this is the wait as opposed to the wait for the other program. Okay.
Okay.
Miss,
All right,
and
Ms.
Miss Hunt,
Primovic?
give me a call, and I'll talk with you more about it. Okay, Miss Hunt? You still have my
Yes.
number?
No, ma'am.
Okay.
I don't have, you have a number?
Can you give her number again? Your number
Oh,
again?
you
She
said I
said she
won't be
doesn't
going
have
to prison.
404-612-7978.
Okay.
Give me a call and we'll talk some more, okay?
Okay.
You're gonna be all right. I'm gonna call your mom and tell her what happened and what's going on, okay? You're gonna complete this and get back home.
Will this take long to get in the program?
Well, that's what we'll need to figure out. They got to figure out which of the two it's going to be, and then they'll be able to answer that for you. Okay.
Okay.
Thank you, Ms. Hunt.
Okay.
Thank you.
Give me a call, Miss Hunt. Thank you. Thank you, Judge.
Call her now? No, she got to do everybody else.
So it's the same Ms. Lovett for positions 11 and 12?
Yes, sir.
Okay. And what are we
And Your
doing
Honor,
with Ms. Lovett?
this is also a termination hearing, and then we are ready for a probation revocation.
Okay, so then the plea is position 13, Ms. Rivers?
Yes, sir.
She's coming, give her a second.
We can do Miss Rivers. 13 is the plea, Your Honor. She was in track 1.
Okay.
There she is, Judge.
There's
Is this Ms. Lovett?
No, this is Ms. Rivers.
Okay, we'll do Ms. Rivers. Before we do that, Mr. Franklin, you're back. Was there anything more we needed to do on Ms. Grant's case?
Points of clarification. First things first, we do waive formal arraignment of the new indictment. I was able to discuss those charges with her.
Okay.
And explain just kind of what role they play in the larger story and the process that we are embarking upon.
Great, thank you.
Additionally, I did put into the group chat, but I can repeat now. Her father's name is Arthur Bishop, and I have given his address, 1374 Cave Springs Road in Douglasville. And finally, and most importantly, I wanted clarification. It was a $150,000 bond. Would she be able to make that through a bonding company? Because I'm not sure her family has that much property.
Hold on one sec. We need to get Mr. Forte. Yes, let's go back on the record in Ms. Grant's case. I apologize. I didn't know how substantive Mr. Franklin's follow-up would be. So we're back on the record in Ms. Grant's case. Ms. Grant has agreed through counsel to waive arraignment.
That is correct, Your Honor.
In the 20 SC case, and Mr. Franklin provided, and we don't need to say it again, her father's name and address. Those will be included in the bond. And then the question was, would Ms. Grant be able to post the bond through a bonding company? And my answer to that question is, I mean for it to be the same type of bond as was set by Judge LaGrua. So I'm just looking that up, and we'll use that language, and the players in the bond world will interpret that as they see fit. What Judge LaGrua said was good bond. And I don't mean to change that language. So it will be $150,000 total good bond. I don't know what a bad bond is, but it's a good bond.
All right. Thank you very much, Arnie.
I think it means not a signature bond, Judge.
That would be a bad bond in this case, in my opinion. So that's not what it'll be.
All right.
If we need to follow up more, Mr. Franklin, let me know. We'll get Mr. Pinion on. We can just do it on the phone. I don't mean to create an additional obstacle. The dollar amount has gone up, but if good bond means bonding company, the judge who first set the bond used that phrase, and I don't mean to change it.
Okay. Yeah, I think we're good. I think that was her major concern. I think we're good now.
All right. Thank you.
Thank you.
All right. I'm sorry that we kept you waiting for a minute.
Oh, you're fine. Go ahead.
Rivers. So was that Ms. Lovett who was in the room for like 2 seconds?
Yes, that was.
Any reason she went away?
Not particularly, but if you would like to proceed with my case so I can go back to bed, I would.
You're in the room, so we're going to handle yours.
Thank you.
This is a plea, Ms. Primovic?
It is, Your Honor. Ms. Rivers was terminated already, and she was a track 1 case. And so we will have to go forward on the 12 SC case as a plea.
Holy smokes, 12 SC, I have it. It's ancient. Okay, well, we need to get on the record then.
Wow.
Mr. Forte, you ready? He's ready. All right. This is 12 SC 112000, an indictment from July of 2012. 2 other defendants have already resolved their case, and we've got Ms. Rivers. Ms. Rivers, I had to cover a few things with you before we start the plea conversation.
Yes, sir.
You have 2 important rights that are you're going to need to waive if you want to go forward today. One of the rights is to be here in open court where you and I are in the same room and the prosecutor and all that.
I would like to waive that right.
Okay, well, that's done. You are there at Union City. I'm here. Ms. Primovic is in the Primovic cave, and Ms. Sellers is wherever Ms. Sellers is hiding out. That's the prosecutor. The other right you have that's implicated by this setup, this virtual plea, is your right to have your lawyer right next to you so that you can say—
I would like to waive that right too.
Okay. You're going to need to make sure you let people finish what they're saying before you answer questions. Otherwise, the court reporter is going to throw his hands up and we'll have to stop. So make sure if Ms. Sellers is asking you a question, even though you know the answer, it's not like Jeopardy. You can't buzz in early, okay?
Yes, sir. I'm sorry.
That's all right.
I'm just really tired. I'm very tired.
I hear that. You'd like to go back and go to sleep. So the sooner you let people finish what they have to say, the sooner you'll be able to go back and go to sleep. Ms. Primovic is not in the room with you. She's where she is, and you waived that right. I heard you say that. You should know that if you need to discuss something with Ms. Primovic in private, there's a question you've got, you don't want to say it in front of everyone else, or there's a matter you need to share with her, just tell me, and we can move the two of you electronically into a private room where no one else can see or hear what you guys are talking about. But I won't know you need that unless you tell me, okay?
Yes, sir.
Great. All right. Ms. Sellers is going to put you under oath in just a moment. Once you're under oath, it's important that you answer her questions and mine truthfully and completely. All right?
Yes, sir.
It's also important that if you have any question about anything, you let me know. Will you do
Yes,
that?
sir.
All right, Ms. Sellers.
Thank you, Your Honor. Would you raise your right hand, Ms. Rivers? Do you swear or affirm that the statements that you will provide to the court today will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your true and correct legal name.
Destiny Danielle Rivers.
You may place your hand down. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
I am 26 years old and I've completed 10th grade and I started 11th grade but did not complete 11th grade.
And are you able to read, write, and understand the English language?
Yes, ma'am, I am.
You understand that you're being charged with the offense of burglary in the first degree?
Yes, ma'am, I am.
And do you understand that that carries a sentence of 1 to 20 years?
Yes, ma'am, I do.
And do you also understand that you're being charged with criminal damage to property, second degree?
Yes, ma'am.
And that carries a sentence of 1 to 5 years?
Yes, ma'am, I do.
And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am, I do.
And have you had an opportunity to review a waiver of rights form with your attorney?
No, we didn't go over the form. I went over the form verbally, but we did not do the physical sheet. I went over her rights with her verbally.
Oh, yes,
And we
ma'am, I
will not
remember.
be having a waiver of rights form entered into the record. I've got the indictment and I'll cover the signature piece later in our conversation, but we're not going to have one of those forms entered in this process.
Thank you. And have you had enough time to speak with your attorney, Ms. Primovic, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am, I have.
Do you need any more time to discuss this case with your attorney?
No, ma'am, I do not.
Are you satisfied with your attorney's services as of today?
Yes, yes, ma'am, I am.
Counsel, do you waive formal reading of the indictment?
So waived.
And do you waive any and all defects in the indictment?
Also waived.
Do you understand that this is a negotiated plea, and that means your attorney, as well as has discussed with myself representing the state about all of the facts and circumstances of this case, and that we've come up with a recommendation for the court. And that recommendation is 2 years probation. Do you understand that?
Yes, ma'am, I do. I have a quick question.
Yes.
Well, I guess it's too early for it, but you can continue. I just asked.
All right,
Do
remember
you need
your
to talk
question.
with me?
Yes, sir.
Okay.
No, ma'am, I don't.
Okay.
Thank you. And do you understand that the court does not have to follow that recommendation?
Yes, I do.
And do you understand that he has the entire range of the sentence to sentence you to in this case?
Yes, sir. Yes, ma'am, I'm sorry.
And do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal court?
Yes, ma'am, I do.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am, I understand that.
And do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am, I understand completely.
And do you understand you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that neither court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes, ma'am.
You understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am, I understand.
Do you understand that pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years?
Yes, ma'am, I understand.
And I do believe that this is a first offender sentence.
That is we are requesting first offender. Thank you.
And have you pleaded guilty to or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am, I have not.
Have you ever been sentenced for a crime, felony, or misdemeanor under the First Offender Act?
No, ma'am, I have not.
Okay. And has your attorney explained first offender to you?
Yes, ma'am, she has.
And do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked and you could be adjudicated guilty? And you could be
yes, ma'am, I have.
You resentenced to up to the maximum sentence for each charge in this indictment.
Yes, ma'am, I have received all that information.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Yes, ma'am.
You understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, ma'am.
You understand that by guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you, or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial. Do you understand these rights you're giving up today?
Yes, ma'am, I do.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
And you are voluntarily, and it is your decision to waive these rights because you are in fact guilty.
Yes, ma'am.
How do you plead to the charges of burglary, and criminal damage to property in the second degree, 12 SC 112000?
I plead guilty.
Is this guilty plea freely and voluntarily given today?
Yes, ma'am, it is.
You understand they have only a limited right to appeal this guilty plea conviction?
Could you repeat that, ma'am?
Yes. Do you understand that you only have you understand that you may have a limited right to appeal this guilty plea conviction?
Yes, ma'am. Which is the limited right?
And that's the next part. You have only 4 years from today for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea. Do you understand that?
Yes, ma'am.
And at this time, the state will go on the record with the facts in this case. Apologize, screen went out. I apologize, my screen is freezing up. Your Honor, if you could give me a second, I had all of this information pulled up on my screen and it has all gone away.
Uh-oh.
Apologize.
That means she's supposed to get out. Mm-hmm. How you doing, Mr. McBurney? Judge?
I'm doing all right. How are you?
I'm great, thanks.
Ready to go back to bed?
Yes, sir, I am.
Ready to get out of Union City?
I would love that. I would really love that. I had a question about. Hold on. Who's your attorney? There you go. I had a question about the place for the probation. Is it possible if I can go to the Cobb County location?
So we'll talk about that. I have to agree that probation is the right sentence.
Oh, I'm
sounds
sorry.
like I will. That's okay. But you will have to start by reporting to Fulton.
Okay.
But if you end up living in Cobb, then
I
that's
do
who would
reside.
supervise you. So we'll cover all that. You're not required to live in Fulton. If the place you're going to lay your head is Cobb, then it will be courtesy supervised out of Cobb. The only thing that's complicated is if you want to live outside of Georgia. But within Georgia, pretty fluidly, the probation folks move the supervision from Fulton to Forsyth to Fayette, wherever you might be, as long as you're updating your address. Okay?
Okay. Judge
All right.
McBurney, she's referring to the reporting instructions paper that we have here. She's looking at all the addresses.
Got it.
I gave it to
We'll
her.
cover that though. She's going to report in Fulton, but she might end up elsewhere. Ms. Sellers, you having any luck yet?
Yes, I have it pulled back up. Thank you.
All right, tell me about this June 26th, 2012 burglary.
Yes, Your Honor. On June 26, July 2012, at approximately 3:20 p.m. at 1264 Easton Street in Georgia, in Fulton County, Georgia, Officer Kane responded to a 911 call. At that call, the defendants, Joshua Daniel Fisher, as well as Walter Lee Matthews and Destiny Rivers, entered the residence owned by victim Dan Wang, located at that address without authority, permit, or consent, and removed a door latch to gain entry to the residence, and removed metal pipes and copper wiring from the walls and the air conditioning and the heating unit. The damage done to the residence from removal of the wiring, pipes, and door latch was in excess of $500. The defendants then placed the wiring and pipes in a bin. Additionally, the defendants took a mini refrigerator from the residence. After the officer responded to that call, he found Mr. Fisher, Mr. Matthews, and Ms. River moving the mini refrigerator from the side of the residence to the front yard. Defendant Fisher and Defendant Rivers then walked to the front of the house, and Defendant Matthews began to walk away from the residence. In the front yard, the officer saw the bin containing the wiring, pipes, and air conditioning and heating parts in it. When the officer questioned the defendants about the situation, Mr. Fisher and Ms. Rivers claimed that they had been living at the residence, but were planning to move out on that day, July 26th, and were taking some of their things with them. Mr. Matthews stated that he was Mrs. Fisher's uncle. Defendants Fisher and Rivers then claimed that they were renting from the owner, Dan. When the officer then asked the owner that if he knew that they were moving out and if he had permission to take the property that was located in the bin, he stated no. Fisher claimed he was unable to contact Dan. Fisher and Rivers then stated that they did not have the key to the residence. The officer then walked to the door to the residence's crawl space and found that the latch of the lock had been removed to gain entry. There were holes in the walls of the house where wiring had been removed, and the air conditioning and heating unit was dismantled. The wiring missing from the walls matched the wiring in the bin in the front. The officer then found a bag containing multiple tools near the crawl space door. The tools included screwdrivers, hammers, saws, and wrenches. Those tools commonly used for burglary. Fisher Rivers stated that the bag of tools belonged to defendant Matthews. Matthews admitted that the tools were his and that he was helping Mr. Fisher with some things at the residence. Officer Baskin then advised that the owner was Dan Wang. Mr. Wang came to the residence and stated that no one had permission to live at this residence, including all of the defendants on the scene. They were then arrested and charged accordingly. Your Honor, this is an 8-year-old case. The other two defendants have pled guilty in this case, and one received 5 years probation. The other received, I believe, a sentence of 5 years to serve 1. Ms. Rivers was allowed to enter the behavioral health treatment court program and was subsequently terminated for going AWOL. The state's recommendation, joint recommendation today is 2 years probation, and to allow her to have this as a first offender. I do not have a felony history for Ms. Rivers. And I do remember looking at this case when it was previously on the calendar, and I did not see that she had any more convictions from that time. So I think that this is a good resolution for all parties.
Okay, thank you for all that. Officer Calhoun, any felony criminal history for Ms. Rivers?
No, Your Honor. We do not show a past history for the defendant.
Okay. Ms. Primovic?
Thank you, Your Honor. Ms. Rivers is 26 years old when this event occurred. She was 18 years old. She was there with her uncle and at the time her boyfriend, and we discussed what was going on and that her uncle and boyfriend thought it would be a good idea to do this, and she helped out at 18 years old. Very fortunate that she hasn't gotten into any more trouble or any more arrests. I've been in constant contact with her mother, her grandmother, her 2 sisters. They all live in the same home. They all live in grandma's house. She has 2 children, one that just turned a year old. She was working at Edible Arrangements and then was about to start with Amazon, and she got pulled over for not wearing a seatbelt and this warrant came up. So now we have
How
her.
long ago was Ms. Rivers, did she go AWOL? How long ago was BHTC and that not working out?
Mr. Tucker, are you on still? She has always kept in contact with him. She would go AWOL, and she always kept in contact with him and he kept checking on how she was doing and things like that. But I don't have, I'm looking through my emails, a date of when she went AWOL.
I know that she initially started in 2012. Like Ms. Krimovic stated, there have been a couple of AWOLs, but I will note that Mr. Tucker, that they were willing to take her back at this time, but Ms. Rivers has decided that that's not what she wants.
Right, 8 years is probably enough to show that that wasn't going to work out. Okay, that's
however,
helpful.
Your Honor. Yeah, however, she wants to, and we're going to suggest going to the Behavioral Health Outpatient Center at 10 Park Place to make sure that she gets her medication and any counseling if needed. Her family said that when she was pregnant, of course, the medications she wasn't taking, of course, but after she had her child, she was starting to get back going now. I see her medications she's on now are making her very sleepy. So hopefully at 10 Park Place, they can work on making it so that she can actually live and work. So we're asking for that, Your Honor, to be a condition of her probation is to go to Behavioral Health Outpatient Center. I've talked to her family about it. And I think she has really good support and that she'll finish up the probation. And probation has also asked me when we talked for her to be assigned a mental health probation officer. Hopefully Cobb County probably has that same.
Okay.
So that's what we're asking for, Your Honor.
So grandmother's house is in Cobb County?
Yes, sir. Yes, sir.
Okay. Got it. Okay. Well, that's a lot of information. Are we aware of an equivalent of 10 Park Place in Cobb County, or does it make sense to have that be home base for treatment?
Go. Well, it is a mental health.
I was actually asking Ms. Primovic if she knew.
There is a Cobb CSB in Cobb County. It's called Cobb Community. I will find out more information, but there is a behavioral health place in Cobb County she can go to.
Okay. Well, we'll start at 10 Park Place. I was just thinking for the convenience of Ms. Rivers, if Cobb is going to be home, if there were an equivalent of 10 Park Place in Cobb County, that might be easier.
Have you been to 10 Park Place before, haven't you?
I know where that's great. No, I think
Rivers, have you?
No, ma'am, I have not, but I do know where it is.
Right. And the family said they'll take her and get her wherever she needs to go. We didn't know of any like 10 Park Place in Cobb County, but if that becomes an issue, I'm sure, or we can say, or something equivalent.
Okay. Well, I don't want to say something equivalent because then someone could fudge. We'll start with 10 Park Place, but certainly probation would be empowered to say whatever it was Ms. O was thinking of in Cobb is adequate.
It's called Cobb County Community Service Board.
Well, I know what a CSB is, but to me, that's too general. Citizens of Cobb can go to the CSB, and we're one of the few counties who don't have one, and get all sorts of care. But I guess I'd want it to be more targeted. And what I'll do is leave it to Ms. Rivers and her probation officer to determine if a place other than 10 Park Place makes more sense. But the sentence is going to say 10 Park Place. And then if it needs to be amended, we can do that. Okay. That is all helpful. Ms. Rivers,
Yes.
I have a couple questions for you, and then if there's anything you want to add. So you have two kids. One is 1 year old. How old is your other kid?
Sasha is 6 years old. I conceived her after I was released from prison. From jail, from the incident.
Okay. And does Sasha stay at your mother and grandmother's house?
Yes, she does. And we do not have
contact with Joshua Fisher.
Okay, I was going to ask that. So Matthews and Fisher is boyfriend or was boyfriend, and Matthews is uncle?
Yes,
Okay, and that's your uncle or Mr. Fisher's uncle?
that's my uncle.
Okay. You staying out of his business too?
Since this incident, I have not had any contact with either one of those.
Okay. Is Mr. Fisher the father of Sasha?
He is.
Okay, and is he trying to be active in Sasha's life?
He has not.
Okay, and you have a younger child, a 1-year-old?
Yes, sir.
Is that a boy or a girl?
He's a boy.
Okay, what's his name?
His name is Jonathan.
Jonathan. And does Jonathan live with your mother and grandmother?
Yes, he does.
Okay, so he's with Sasha.
Yes, he is.
All right, and is Jonathan's father active in Jonathan's life?
Yes, he is. He's actually active in both Jonathan and Sasha's life.
Well, that's a good guy. You're lucky to have him plugging in that way. I'm happy for Sasha that Sasha has a father figure around. Ms. Rivers, I need to ask you a little bit about first offender. Ms. Sellers already did it, but I'm obligated to do it as well. First offender is primarily an opportunity for you. It means that this is not a conviction. You'll have a sentence. It'll be 2 years. I'll let you know now, I'm going to follow the recommendation. So it's a 2-year probated sentence. But you are not a convicted felon. So if you're trying to go to work, you don't have to check the box that says felon or anything like that. And that's the way it will stay, provided you stay out of trouble. If you finish your sentence without getting into trouble, it all goes away. It was never a conviction, and it does not become a conviction. That's the upside. Do you understand that?
Yes, sir.
Okay. Do you want to take a break, or are you okay?
I'm okay, sir.
Why are you feeling sad?
I'm not feeling sad. It's tears of joy because this has been hanging over my head for 8 years.
Okay. Well, then you're feeling happy. I'll let you be happy, but I need to make sure you're able to follow what I'm saying.
Yes, sir. I understand completely.
Okay. So I talked to you about the good part of first offender. You need to understand the risk of first offender as well, because you are choosing to be first offender. You don't have to do it. If during your 2 years on probation, there's a big problem, meaning you get arrested for something serious, you could come back in front of me and I could revoke not just your 2 years, I could revoke your first offender, and then I would have 25 years to work with, 20 for burglary plus 5 for the criminal damage to property. So, and this is a hypothetical, if a year from now you get arrested because you shot someone, you're not going to do that. But if you did, independent of you shooting someone, I could say, well, you know what? I'm going to revoke your first offender. I'm going to send you down the road for 20 years because you shouldn't have gotten first offender. You're a dangerous person. You shot someone and you don't get a trial. You've already pled guilty. I was there with my boyfriend and my uncle, and we did this stupid thing. So that's the risk side, is that if things go really haywire for you during the 2 years and you get in trouble for something serious, that could cause this case to be resentenced. Then you'd be a convicted felon, and it could be a whole bunch of time if all these bad things were to happen. Do you understand that?
Yes, sir, I do.
Okay. Are you comfortable taking that risk and accepting the benefit of first offender, which means no conviction?
Yes, sir, because within these 8 years, I haven't been in trouble. So I think it's a real good.
Okay. And you and Ms. Primovic have talked about it, and I'm very comfortable sentencing you as a first offender. I just need to make sure you understand that there's a risk associated with it, and I find that you do understand it. Ms. Sellers, is there any restitution that's due? I noticed that one of the sentences, I think it was Mr. Fisher's, that his probation became non-reporting after he paid restitution. I don't want Mr. Wang to get more than he should. That was 8 years ago. Who knows if you can find him, but I am obligated to ask whether we need to make restitution part of the sentence.
Your Honor, I did reach out to Mr. Wang and was unable to get in contact with him. So at this time, no restitution, Your Honor.
Okay. Ms. Rivers, I find there's a factual basis for your plea. You and your boyfriend, your ex-boyfriend, and your uncle did this thing that I think all three of you knew was not the right thing to do. It caused a lot of grief and heartache and expense for Mr. Wang. Bad choice, but it was 8 years ago. And I think this is a reasonable resolution. So I'm going to accept your plea. I find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea, but that you're doing it because you think it's the right way forward for you. Is that correct?
Yes, sir.
Then I'll accept it that way. Knowing means that you've understood all the things we talked about and you don't have any questions. But I'm remembering that early on you said, hey, I've got this question. Do you still have a...
No, sir. You already answered the question, but I would like to apologize on record to Mr. Wayne for my involvement in the crime, and also that unfortunately he's no longer living, he's deceased. So I would like to apologize to his family.
Oh, how do you know Mr. Wang is deceased?
We were living in a community where he has multiple rooming houses.
Okay.
And he was a victim of an armed robbery and he passed away.
Yikes. Okay. Well, I appreciate you sharing that. And on his behalf, I appreciate you apologizing for the mistake you made a long time ago. Ms. Rivers, I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, if you have a small problem, maybe you miss a meeting or you're behind on paying something, you don't have to come see me. You'll only come see me if you have gotten in trouble with the law again. And then it's a bigger deal anyway, because you're a first offender and that's a high stakes thing for you. But for minor probation issues, you and probation will sort that out. I will sentence you to 2 years on count 1 and 2 years on count 2. Those will run concurrently with each other, meaning at the same time, and those will be on probation. I will waive your probation reporting fee for the first 2 months. I will make it a special condition of your probation that you report to 10 Park Place within 30 days of release, so that you can set up a string of appointments to make sure you're getting the medicine you need. And if the doctors there recommend that you get counseling or whatnot, you'll need to follow their recommendations. They're the experts in that subject, not me, not your lawyer. But it sounds like at a minimum, they're going to want you to take some medication that'll help you stay in a good frame of mind for your kids and your family. And that'll be part of your probation. I'm also going to ask that, I guess to call it more formally, it's the Behavioral Health Outpatient Center at Grady, which is 10 Park Place. I'll also ask probation to assign you to a probation officer who specializes in mental health treatment, so that he or she will be particularly attuned to the needs that you've got. You do need to report in Fulton County for probation. You'll be supervised out of Cobb, but your initial stop will be an address that you're going to get from Officer Calhoun in just a moment. And you'll need to get there within 72 hours. So if you don't get released today, it's 1 o'clock now, you ought to be released tomorrow. So Monday or Tuesday of next week, you need to go to this address, and we'll tell you the address in just a minute. But you'll need to show up and say, I'm Destiny Rivers, and I need to know how supervision is going to work. You want to give them your address, because then they'll say, oh, that's Cobb County. You're going to want to go here or there or do whatever. But if you don't report within that 72-hour window, I get a warrant to sign for your arrest. And those always make me sad, because that means someone has started off in exactly the wrong direction. Okay?
Yes, sir.
Officer Calhoun, can you share with Ms. Rivers that address?
Absolutely. Actually, Your Honor, I'm going to change that reporting for her. Since she's getting out immediately, I'm going to schedule her to report on Tuesday, June the 9th at 9 a.m. And I need for you, Ms. Rivers, to report to 276 Memorial Drive. And that's Atlanta, 30303. Once you report to probation, please bring something to verify your address, like utility bill, cable bill, something. And verifying your address in Cobb, and then they will transfer your supervision out to Cobb.
Yes, sir. Thank you. June 9th, sir?
It's going to be Tuesday, June 9th at 9 a.m. and you're reporting over to the Fulton County office at 276 Memorial Drive. Now,
Yes.
failure to will result in a warrant being requested for your arrest. So let's make sure we report Ms. Rivers, and best of luck to you.
Thank you so much.
And Ms. Rivers, I'm going to email that to your sister and call your family and give them that information too, okay?
Hold on, we're not quite done. We're not quite done. So, Ms. Rivers, I didn't mean to give you wrong information. Officer Cahoon did a switcheroo on me. Other folks today, we've said you've got 72 hours. You've got a specific date and time. So you have a specific appointment. They'll be looking for you. I know you wrote it down. That's good. 9 a.m. on June 9th. So don't miss that. That's, other than hugging your kids again, that's your most important date after you get out. But you'll have a little while to get organized for that. This is your indictment. In order to officially enter a guilty plea, in theory, you would sign it, your lawyer would sign it, and the prosecutor would, but you're where you are, I'm where I am. Do you, Ms. Rivers, authorize me to sign your indictment on your behalf?
Yes, I do, sir.
Ms. Primovic?
Yes, Your Honor.
And Ms. Sellers?
Yes, Your Honor.
Great. I will sign the indictment, and that will take care of the case. And with that, I do think we're done, Ms. Rivers. Do you have any questions?
No, sir, I do not have any questions.
All right, good luck with everything.
Thank you.
Take care, Ms. Rivers.
Thank you. Have a great day.
Just sit right here. She don't come take.
So I believe all that's left is Ms. Lovett. She's back. All right. And Ms. Lovett is it going to be they're both track 3 or 4 cases, so it's a revocation?
Yes, Your Honor. I believe she needs to be formally terminated.
Sure.
All right, thank you.
Then we would be ready to do a probation revocation.
Okay. All right. So you can stand down, Mr. Forte, unless I invoke you. And we'll turn to Ms. Lovett, which is 2 positions. Hello, Ms. Lovett.
Hello.
I'm Judge McBurney. I don't think we've met. I think you've worked with Judge Reeder before. I am an accountability court judge, but I don't work with the BHTC clients. I work with the drug court clients.
Okay.
I'm going to ask either Ms. Sellers or I see Ms. Bain came alive. She may be the one who's going to be telling me a little bit about why they're seeking your termination. We'll talk a little bit about termination, assuming that's what we do. Then we'll talk about what's going to happen with your probation. Okay? Ms. Lovett, before we do that, though, I need to ask you a couple questions.
Yes, sir.
Normally, the way we would handle this is that you would be here in court. And your lawyer would be here. We'd all be in the same room. But because of the health crisis, we're not able to do that. Do you waive your right to be here in court?
Yes.
You're okay proceeding this way, virtually?
Sure.
Okay. And the other right I need to ask you about is your right to have your lawyer, Ms. Primovic, right there by your side. Normally, she'd be sitting next to you and she wouldn't have to wave. She could just whisper something to you. You guys could exchange notes. But we can't do that in this system. It has to be virtual. Are you okay proceeding that way?
Yes, sir.
Great. Well, please know this, Ms. Lovett. If you need to ask Ms. Primovic something private or confidential, we can move you to a breakout room, a sort of virtual conference room where it will be just the 2 of you. That's the only face you'd see on the screen would be Ms. Primovic, and you guys can speak in private. So if you need that, will you let me know?
Yes, sir.
Great. All right, Ms. Bain or someone, let me know, please, why BHTC is seeking Ms. Lovett's termination.
Your Honor, I'll just start off very quickly. Ms. Lovett had a few tries at behavioral health court. She was initially admitted back in 2016 under her 16 SC 143569 case, and she was terminated. Remembering that she went AWOL on several occasions. She was allowed back into the program in October of 2019 on her 19 SC case, 19 SC 169745, where behavioral health treatment court is a condition of her probation. And again, Ms. Lovett has gone all that the behavioral health treatment court staff can give a little bit more light on Mrs. Lovett's behavior and participation while in the program.
Okay.
Yes, Your Honor, and hi, everybody. So Ms. Lovett has never really participated in the program, especially after she was released a second time. We were willing to give her a chance after she was already in the program back in 2016. But at this time, we just feel like she's too much of a flight risk and that she's not really wanting to actually work the program. So we'd like to move forward with the recommendation of termination.
Okay. Ms. Lovett, well, before I ask Ms. Lovett, Ms. Bain, were we providing housing for Ms. Lovett so that she was leaving not only the treatment, but also a residence, or was she providing her own housing?
So it initially started off that she was trying to provide her own housing, and she gave us an address, but then the address didn't lead anywhere. I think it was to stay with her mom. Our investigators went to check it out and tried to leave a card, but it was just very confusing. So then we started looking for housing. And before we could identify housing, she was released without us knowing, but she never returned, never.
Okay. Okay. So Ms. Lovett, it sounds like it's been complicated for you to stay plugged into the program. Is that a fair statement?
It's true, Your Honor, but I have to take care of my mom. My mom and my daughter. My mom has cancer and my mom has Alzheimer's. I can't just do the I'll be trying. I want to do better, but I'm not an addict, Your Honor. I came by doing it the wrong way. I owe up to my estates. I apologize for not doing the program, but the program is not for me. I don't take care of medication on the street. I don't take it in jail. I'm straight. I'm trying to take care of my family. Because my family come first before anything. Listen.
You mentioned you're taking care of your mom and your daughter. How old's your daughter?
My daughter is 6.
Okay, so you've got a young one and an older one that you're trying to take care of. And where is home for you when you get released? Where are you going?
3670 Beaver Trail Lane, Riverdale, Georgia.
And is that your mom's place?
Yes, sir.
Okay, got it. Okay, Ms. Primovic, I am going to terminate Ms. Lovett from BHTC. It sounds like it's a mutual decision.
Yes, sure.
The folks at BHTC are trying to help, but are having a little trouble keeping Ms. Lovett around. And then I just heard Ms. Lovett explain that she appreciates the efforts, but it's not the program for her. That tells me that we probably are trying to bring together the wrong two groups, BHTC and Ms. Lovett. So I will terminate her, and we need to work through what to do with her 2 cases. What is your suggestion?
Well, Your Honor, Ms. Lovett and I have had a couple conversations, and she is just so focused on taking care of her mom, who's very ill, and her 6-year-old, and that she is adamant, as she's already said to you, that she's been clean and sober. She doesn't need any medication. She doesn't need any counseling. She says the only time she has any issues with her mental health is really it's an anger issue, and it's when she is really, 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 really upset. But beyond that, she has no issues with it. Her mom had a cleaning service that she helps out with. Her mom really can't run it anymore because of her illnesses. So she is able to work. Her mom, someone else has the cleaning service now. She's able to work there when she's not taking care of her 6-year-old and her mom. So we've had some conversations about different programs that we could ask you for, and if you and if she thought she would be appropriate for any of the programs that I had discussed with her. And she said that she really does not want any programs and that she doesn't need it. And then she would like to talk to you specifically on why she doesn't need the programs, which she's already done a little bit already, but she's asked that she wants to talk to you directly about not needing any programs.
Okay. I'll hear from you in just a moment, Ms. Lovett. I have a couple questions. One is, who takes care of your daughter when you end up in a situation like this?
It's usually the lady next door, the next door neighbor. I don't really have her phone number because I have it in my phone. That's at home, well, improperly. She really takes care of my daughter, and her daughter takes care of my mother when I'm not there.
Okay. And your mother, it sounds like, is not able to work. Is she, and you want to help take care of her?
Yes.
Is she mobile? Is she able to get around the house and things like that? Or what's the situation?
She can move, but she can't move on her own. I have to be able to hold her, to make it to the bathroom, help her, do what I'm supposed to do.
Okay. You mentioned that you don't use drugs, you don't have an addiction, whatnot. You pled guilty just a few months ago to possession of well, I guess it was marijuana, no, cocaine. You pled guilty to possession of cocaine, and you were arrested with that stuff back in July of last year, so it's not all that long ago. That to me seems like a disconnect. You say there's no issue, but you got caught with drugs. Tell me what I'm not understanding.
I apologize for that, Your Honor. I was trying to get some money to try to get some food with, and I went doing it the wrong way, and I owe it to my estate.
So you were selling drugs, or you were using
I was
drugs?
trying to, but I did a bad job. I know not to do that no more.
You're not a good drug salesperson.
No.
Okay.
I see that.
So was that case one where you tried to sell to an undercover officer?
I didn't know if it was an undercover officer or not.
Well, maybe the undercover officer was just doing a real good job and you were doing a fine job. Who knows? So what you're telling me is that situation where you got caught with drugs, they were yours, but they weren't yours to use. They were yours to sell.
Yes, sir.
Okay. All right. So what should we do? What is it? I mean, what do you think the right solution is here?
Keep me on probation. Whatever the probation officer want me to do. I know I probably never reported because I didn't have no way to get there, but I have a car now at home. I have transportation to be able to get to and from the probation officer. If they would reinstate me on probation, whatever the police want me to do, hey, I'm with it.
Why do you now have a car?
I've been had one. I just never just learned how to drive.
Do you have a license?
Yes, sir.
Okay.
I'm in progress of getting one.
So you don't have a license, but you're trying
But
to
I have
get
a learner's. I have a learner's permit.
a learner's. Okay. Ms. Sellers, what's the state's view on this?
Thank you, Your Honor. First, on the two cases, the 16 SC 143569 case, Ms. Lovett was sentenced to 8 years to serve 3 years. The balance of 5 probated, and those 3 years were commuted to time served upon our entry and completion of behavioral health treatment court. So it was a part of that sentence that she complete behavioral health treatment court. Additionally, in the 19 SC 169745 case, the possession of cocaine case, she was sentenced in October of 2019 to 6 years to serve 6 months, and that 6 months was commuted to time served upon entry and completion of behavioral health treatment court. Again, behavioral health treatment court was made a part of her sentence. So the court in both of those cases believed that Ms. Lovett had a substance abuse problem as well as behavioral health issues. Ms. Lovett's criminal history is quite significant. She has 12 felony convictions in addition to the 19 SC conviction. So that includes the 16 SC conviction. And from 2008 to 2019, that spanned of cases. One is a terroristic threat. One is a forgery in the first degree. The remainder of the cases are possession of cocaine or possession of cocaine with intent to distribute. The state believes that Ms. Lovett does have a substance abuse problem. And the state's recommendation today is to revoke 2 years, commute that to time served upon her entry and completion of integrated residential substance abuse treatment through the probation department of community supervision.
Okay. Thank you for sharing that. And I was able to pull up the repeat offender notice that was filed in the 19 SC case that got Ms. Lovett's case into the complex division, and it lists 21 felony convictions. Okay. That's a lot. Okay. Ms. Lovett, do you have other family in the Atlanta area? Obviously, your mother is here because you live with her, and your daughter's here. So they're the three of you. Do you have any brothers or sisters?
No, sir.
Aunts or uncles?
Not in the state of Georgia.
Okay. So your mom's brothers or sisters are not here in Georgia?
My mom's brother is deceased. My mom's sisters are in Fort Lauderdale, Florida.
Okay. And does your mom's sister help some with your mom?
Nah. Yeah.
Okay. Do you have other kids besides your daughter?
Yes, sir. They in the state's custody right now.
Are they older or younger than the daughter who's staying with you?
One is 16 and the other one is 11.
Okay. All right. So Ms. Lovett, tell me why you think that if you went back to take care of your mom and your daughter, we would see different things happen than we've seen over the last 20 years. And why are things different now?
Well, me sitting in here, and I know I've said this to them too many times, but me sitting in here now has got me thinking about my life, about my future, about my mom, about my baby, my little girl. I want her to grow up to know that her mother is not a bad person. I want my daughter to see that her mother is doing what she's supposed to do, to be a better mother to her. Not spending my time out on the streets doing what I'm not supposed to be doing. I want my mom to know that her daughter is there for her. My mother may not have been there for me when I was little, but I'm trying to be there for my mom now. And I know my mom needs me, and I need my mom.
Officer Calhoun, are there other open cases for Ms. Lovett besides these two?
No, Your Honor, only show those two probated cases previously mentioned.
So I have down here an 18 SC 159110. That's closed out?
Yes, Your Honor, I'm not showing that case on probation with us.
Okay.
Your Honor, in that case, 18 SC 159110, that's a possession of cocaine. She received a 3 years suspended sentence in June of 2018.
Okay, so that wouldn't hit probation's radar anyway.
No, Your Honor.
Okay, got it. All right. Well, Ms. Lovett, I am impressed with your passion for wanting to be there for your mom in a way perhaps she hasn't been for you all the time. And as well, your desire to be a different role model for your daughter than maybe you were for your older kids. I want to help you with both those things. I am not confident that you are there yet. I know you feel you're there and you want to be there, but those are different than your capability of being there. And everything that I've heard from the BHTC staff and from looking at where you've been over the last few years tells me that I would not be doing your mom a favor or your daughter a favor. And really, most importantly, you a favor to say, you know what, let's just not worry about things. Get back out there and just be who you've been for a while now. I think something needs to change. And I don't believe that 45 days at Union City is the thing that makes that change. I think you need some structure for a while in a way that BHTC couldn't provide. That's not a residential program. You can walk away from it, which you did on a number of occasions. And so I am going to revoke your probation, but I'm only going to revoke it as long as it takes you to get through the program that will help you develop some of the coping mechanisms and skill sets that'll make you that better daughter and better mother that you want to be. So I will revoke 2 years of your probation, but I'm reducing that, shrinking it down to the time that it takes for you to enter into and complete either the RSAT program or the IRSAT program as determined by the Department of Community Supervision. Your completion of that program will cause the revocation to end, and then you'll be back out. You'll be on supervision. There'll be aftercare. There'll be folks who can help you find work, etc. But you will be in a much better position to be that mom and that daughter and that caregiver that you want to be after you have worked your way through one of those programs.
Yes, sir.
Do you have a question about that?
Do I have to stay in jail?
So yes, you'll be where you are until you can be admitted into either of those programs. So you'll be interviewed so that folks who know more about this stuff can figure out which of the two programs you'll go to. But until then, you're gonna be where you are so that we know, one, how to find you, and two, we're confident that you're not doing something that's gonna hurt you.
Can I say something, Your Honor? May I say something?
Yes, ma'am.
Your Honor, you ain't gotta worry about me doing nothing wrong. Please let me be able to go home to my mom. I promise y'all won't have no trouble with me. I promise on everything. You can put me on house arrest. I promise. Your Honor, please. I need to be with my mom. Please.
So I hear your concern, Ms. Lovett, but I need you to be in a position to help your mom and not make things more complicated for her, okay?
I won't make nothing complicated. I'm not a bad person. Please, Your Honor, give me
You are not a bad person. I agree. This is not about you being a bad person. It's about you being a sick person and needing some help.
I'm not sick, Your Honor. I'm not on drugs.
Ms. Primovic, was there something you wanted to add?
No, I just wanted to tell Miss Lovett to give me a call. You have my number that you called before? Give me a call. Okay? Give me a call. You're going to be okay. You're going to be much better for your family. You're going to be okay. You're going to be okay. Give me a call. You're going to be okay.
How long is it going to take?
Hold on. Can you give it back to me?
404-612-7978.
Okay.
Thank you, officer.
How long is it going to take?
So when you talk to Ms. Primovic, she can talk to you about that, okay?
Okay? Give me a call. You're going to be okay. You're going to be all right.
I think that completes things at Union City. Thank you, South Annex, for all your time.
Thank you.
Officer Calhoun, do you need anything more from me to prepare the revocation orders in the two cases for Ms. Lovett?
Your Honor, I'm getting ready to submit those orders to you right now for Ms. Lovett. I'll have them over to you in a matter of minutes.
Okay, but so the wording you've got, I said what you needed?
Yes, Your Honor.
Okay.
Thank you, Your Honor.
All right. Well, folks, I'm sorry we ended on that note of upset. I understand what Ms. Lovett wants, but you handled it very well, Ms. Primovic. She doesn't seem to want any program anyone would find for her. She's got her own program, and that's not going to be a program that puts her in a place to meaningfully help her mom or her daughter. So that's a tough ending, but we got through a lot of cases, and hopefully for the Destiny Rivers of the world, they can be on to taking care of things. And For others, they'll be heading in different directions. But I want to thank all of the sheriff's staff for getting folks ready. And I think I followed the order that was requested. It may have taken a little bit longer, but we had a few things that were a little more complicated. Ms. Sellers and Ms. Primovic, you were ready to go on the many accountability court cases we had. Mr. Tucker, you and your team were great. It was nice to meet Ms. Bain and others I haven't met yet from the BHTC side, but thank you for dialing in. Ms. Vortis, I've seen my email box ping as you've been sending me the final disposition, so I'll get to those. FC trial calendar, Ms. Pineda, thank you for getting people into their private rooms when they needed to get into their private rooms. Anyone have any questions or concerns that we need to work through?
Thank you, Judge.